He said that like I'd be putting the people in jail. Mr. Higbee.
Welcome back to Myth and Reality, where today's case dives into a high-stakes moment in Wayne County, Michigan. The defendant, Stephen Robert Laffey, is facing a moving violation charge that left a victim with life-changing injuries. The prosecution alleges that Laffey's car struck a pedestrian, resulting in the loss of a leg. But here's the twist. Laffey wasn't reckless, drunk, or distracted. Instead, his lawyer claims a sudden medical emergency caused him to black out. Now, the courtroom must decide, does medical documentation outweigh the devastating harm done? This case isn't just about guilt, it's about responsibility, accountability, and how the law handles accidents that blur the line between fault and tragedy. Stick around, because what unfolds next includes surprising leniency, legal technicalities, and a resolution you might not see coming.
All right, I'm ready on Laffey. This is case number 254535401, the people of the state of Michigan versus Stephen Robert Laffey. Defendant is charged with one count of moving violation causing serious impairment, but not death. And today is the date set. It was set for a motion hearing if one had been filed, and then a final pretrial conference. Appearances, please.
Good morning, Your Honor. Alex Hill on behalf of the people.
And good morning, Your Honor. May it please the court, Robert Higbee, P82739, appearing on behalf of Mr. Laffey, who is present via Zoom. Mr. Laffey, please state your name for the record.
Stephen Laffey.
All right, today is the date set for the final pretrial conference. Mr. Higbee.
Your Honor, we have reached a resolution of this matter, which either myself or Mr. Hill can put the terms on the record, but we have resolved this matter.
Okay, give me 1 second. Mr. Flanagan.
Yes, Your Honor.
I just noticed that Mr. Cripps, in fact, had 2 cases on my docket. And his client on the second case is not here. Can you maybe reach out to his office? Because especially if that's not going to be if it's going to be an adjournment, should the person not appear, then we can go ahead and put it on for the same day that I gave Mr. Cripps. But if it's going to be a habeas, let's reach out to his office. He didn't even say anything about that second case.
Okay, yes, ma'am.
All right, I do apologize. Mr. Hill, what is the offer from the people?
Your Honor, the people have made an offer to accept a no contest plea due to lack of memory to the moving violation causing serious impairment, and we would also have no objection to a delayed sentence, 771, whereas if he successfully completed the terms and conditions.
Here's where it gets interesting. The prosecutor is offering a no contest plea with no upfront jail time. That means Stephen Laffey can essentially accept guilt without directly admitting to it, thanks to what's known as lack of memory. The key here is the delayed sentence under Michigan law. If Laffey follows all court conditions, this charge could eventually be dismissed. That's a massive break, especially considering the victim lost a leg. Viewers, let me ask you, does a medical blackout justify avoiding jail, or should the injury alone carry a harsher consequence? Drop your thoughts in the comments.
The case itself has the opportunity to be dismissed. The Secretary of State and the points are separate than that, but that's my understanding is this qualifies for a delayed sentence. Lastly, we are happy to meet you in a breakout room, but my offer was to not oppose no upfront jail, so that there would be no upfront jail. If the court was inclined to sentence him to jail, then he would be eligible to withdraw it. And that was because of some documents I got from his medical professional that sort of explained why the accident happened.
There's no mandatory minimum jail sentence, is there?
No, Your Honor, it's a 93-day misdemeanor.
Oh, okay. Well, he said that like I'd be putting the people in jail. Mr. Higbee, causing death. Causing death. That's where jail. That's where Wayne County comes into play. Causing death. Okay. So the offer is a no contest plea as charged with a delayed sentence and no jail. That's the people's offer?
Yes, Your Honor.
All right.
And for the court to set other terms and conditions of
Yes,
probation.
of course. And,
Yes.
okay. So, Mr. Laffey, your lawyer indicates that you would like to accept the people's offer, enter into a plea today, no contest plea as charged with the terms that I placed on the record. Is that what you want to do, sir?
Yes, Your Honor.
All right. Mr. Laffey, I'm going to share my screen momentarily. When I do, on it, you will see an advice of rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer, your constitutional rights?
Notice how carefully the judge explains every right Laffey is giving up by entering this plea. From waiving trial to the possibility of appeal, it's all on record. This ensures the plea is airtight against future challenges. But here's the dramatic point. Even though the prosecutor won't push for jail, the judge still reminds Laffey that technically he faces up to 93 days behind bars. This is the legal safety net. If Laffey slips up later, the court has leverage. Do you think that reminder alone is enough pressure to keep him compliant?
Yes, Your Honor.
All right. And then let me share. Hold on. Okay. Sir, when you went over your constitutional rights, did you understand them?
Yes, Your Honor.
Sir, do you understand that this is a misdemeanor and therefore you do have a right to a trial? However, I'm going to draw your attention to number 6. If I accept this plea from you today, you're going to be giving up your right to a trial. Do you understand that?
Yes, Your Honor.
Has anyone threatened you in any way or promised you anything that was not placed on the record today with respect to the offer and your plea?
No, Your Honor.
Now I'm going to draw your attention to number 8. Are you currently on probation or parole?
No, Your Honor.
Finally, sir, I'm going to draw your attention to number 11. Do you understand that by entering into this voluntary plea, you may be giving up your right to the automatic appeal to the circuit court? And if you were to change your mind about the plea, you would either have to request permission of this court to set aside your plea or request permission of the circuit court to appeal the conviction.
Yes, Your Honor.
All right. And then there was some discussion a little earlier with respect to the plea, you entering into the plea with understanding that I was not going to send you to jail up front. And so my question to you in that regard is, do you understand that I have no intention to send you to jail up front? However, this is a misdemeanor punishable by up to 93 days in jail. There's no mandatory sentence, but the maximum penalty could be up to 93 days in jail. And for example, violation of your probation could result in you going to jail. Do you understand that?
Yes, Your Honor.
With that understanding, do you still want to enter into this voluntary plea today?
Yes, Your Honor.
Thank you so much. All right. Who's going to put the factual basis for the plea on the record?
I'm happy to, but I defer to Attorney Higbee.
I prefer that Mr. Hill does it, given that it's a no contest plea. I wouldn't want any statements that come from me to be able to be used against Mr. Hill, or excuse me, against Mr. Laffey at some point. So I prefer that the prosecutor does it.
Mr. Hill?
Your Honor, according to the investigator's report, on February 3rd of 2025, Mr. Stephen Robert Laffey was operating a motor vehicle in the city of Detroit, county of Wayne, specifically at the James Cousins Freeway near Greenfield. He was involved in a motor vehicle accident where his vehicle left the road and did strike a pedestrian, causing serious impairment of bodily function. I believe that victim lost a leg, Your Honor. And then
This is the emotional gut punch of the case. The pedestrian didn't just suffer an injury. They lost a leg. The prosecution frames this clearly for the record, even though they acknowledge the medical emergency defense. Here's the tension. The law is strict liability, meaning intent doesn't matter. Laffey didn't mean for this to happen, but the statute still holds him responsible. This balance between compassion for his condition and justice for the victim is what makes these cases so tough. Imagine being the victim's family. Would you accept this resolution, Or would you demand harsher accountability?
I do understand the purpose, the basis of the no contest plea is due to lack of memory. Mr. Laffey was experiencing a medical emergency. I have received documentation from his medical professional that indicates he had fainted or passed out at the time of the incident. However, this statute is strict liability. And with that, the people are satisfied, Your Honor.
Okay, Mr. Higbee, do you stipulate to that factual basis for the purposes of this plea only?
Yes, Your Honor.
Court will receive the stipulation and in doing so is satisfied and will accept a no contest plea to one count of moving violation causing serious impairment. Court is going to set the matter for sentencing. Mr. Flanagan, can you pull September 30th for me? Is that a good day for you, Mr. Higbee? Should I set it on that day?
That day is fine for me, Your Honor.
All right, Mr. Flanagan, what is my docket looking like?
6 total, Your Honor, 2 sentences already.
Okay, the court is going to set the matter for September 30th. So that gives me 3 sentencing, so no more, if I could help it. And I am going to order a pre-sentence investigation because I do probably need any information that may be available if there's going to be any request for restitution, which it sounds like there may be, unless the...
Now we see the legal machinery turning. The judge orders a pre-sentence investigation, which digs into Laffey's background, medical history, and financial ability to pay restitution. That word, restitution, is critical. While the criminal court might not impose jail, the financial and civil side of things could be devastating. The victim, after all, has medical bills, rehabilitation costs, and a permanent disability. This is where justice shifts from punishment to compensation. Viewers, here's a question. Do you think financial restitution can ever truly balance out the loss of a limb?
Victim decides that they're going to just pursue it civilly. And then, of course, the victim does have a right to appear, make a victim impact statement. Mr. Laffey, you have a right to be sentenced in person, but you may consent to being sentenced on Zoom. And since I've already indicated that I don't have any intention of sending you to jail up front, Zoom is an option for you. What is your preference, though?
Zoom, Your Honor.
Court sets the matter at 9 a.m. on Zoom. Prior to the sentencing, you will submit to a pre-sentence investigation through the probation department. Sir, they're going to contact you by telephone. If they cannot reach you, they are going to leave you a message and mail you a letter directing you to contact them. Make sure you do so that I can have a proper pre-sentence investigation on the date of your sentencing. And I would like that medical information included, not necessarily attached, Mr. Hill, to the pre-sentence investigation, but it may need to be something that's sent directly to me so that I'll have it as a part of the record.
I was going to
part
ask
of my record.
Excuse me, Your Honor, I'm sorry. I was going to ask if we were to submit information like that, how far in advance of sentencing would the court like that so it has an opportunity to review it?
I'm only going to read that report about the day before or 2 days before at the max.
Okay, Your Honor.
So the week before is good.
Okay.
Yeah, if you want to do a sentencing memorandum, if you get it to Mr. Flanagan by that Friday, that's good.
Okay, Your Honor. Thank you.
Okay. All right. And also, Mr. Higbee, I do need you to contact Mr. Flanagan this morning and make sure we have the current address and phone number for your client so that we can send that over to probation and they can contact him for the pre-sentence investigation.
I will do so, Your Honor. Thank you.
All right. Anything further?
No by the people. Thank you, Your Honor.
Nothing from us, Your Honor. Thank you.
We're all set. Everyone have a great day. Stay safe.
You too.
Thank you, Your Honor.
You're welcome. Thank you.
So, here's where the case stands. Stephen Robert Laffey has entered a no contest plea to a moving violation causing serious impairment. Thanks to medical records, the prosecution isn't pushing for jail, but the judge has made it clear that probation violations could change that. A pre-sentence report and restitution assessment will guide the final decision. On one hand, we see mercy for a defendant with legitimate medical issues. On the other, we see a victim facing lifelong consequences. That's the delicate balance of justice in action. If you found this case as shocking as we did, make sure to hit that like button Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.